Welcome. This video is designed to provide you with valuable information on the topics of wills and guardianship. The focus of the video is on British expatriates living in Dubai. However, the content will be useful for many other people too. I'm Stuart Porter, founder of Great British Wills and your host. Please remember the following is only intended as information. You should seek the services of a qualified will draftsperson before taking any action. For more information and important notices, please visit our website greatbritishwills.com. In this video, I will cover the following three topics. What happens if you die without a will? Whether a will prepared under the law of your home country can be used to distribute your assets in Dubai, and what other options exist. At Great British Wills, we specialise in providing wills for British expatriates. Surveys from the UK suggest that 50 to 60% of adults don't have a will. This percentage is higher for younger people, such as expatriates. So what happens if someone from England or Wales dies without a will? If you don't prepare a will, there is a statutory will in place for you, prepared by the UK government. This will is known as the rules of intestacy. The way your estate is distributed will depend upon your family structure. Under English law, for a married couple with children, the distribution of assets under the rules of intestacy are: the surviving spouse receives the first $322,000 of assets, plus all personal possessions. The surviving spouse also receives half of assets above £322,000. And children of the deceased receive equal shares of the other half of the amount over £322,000 at the age of 18. In the event of both parents' death, the courts decide who will be guardians for young children and manage their inheritance until they reach the age of 18. There is no distribution to unmarried partners, stepchildren, or former spouses. The most common concerns I hear when expatriates learn about the rules of intestacy are the fact the courts decide who looks after their children and their children's inheritance, the thought of an 18-year-old receiving a large sum of money without any parental control is a concern for most parents, the potential loss of focus on their education, and the fact that they would not have the opportunity to learn the life lesson of how hard it is to earn money. There's also the additional potential higher tax burden it forces on those who are left behind. And finally, the UK rules of intestacy also contradict the rules of succession within the UAE. This can lead to further delay at a time when your family could do with minimal bureaucracy. UK government-sponsored website moneyhelper.org.uk recommends that those who have assets outside of the UK to have a will and to receive professional advice on its preparation. Where there is no will in place, the local courts in the UAE will assume that you knew you were in a different legal jurisdiction. They will also assume that if you had any objection to the way your assets would be distributed under local law, you would have given them some direction in the form of a valid will. There is a common assumption that in the event of the death of a married woman, all of her assets automatically go to her husband. This is not the case, following the introduction of a new law last year. Home country wills can cover assets worldwide in many, but not all cases. UAE federal law permits the use of home country wills for the distribution of assets within the UAE for non-Muslims. However, this is not the most legally robust solution, and you are strongly recommended to seek legal advice before relying on your home country will. Some of the reasons for this include certain assets are excluded from this provision, for example, real estate within the UAE. Probate, the process of winding up and distributing your estate, will be via the local courts. Proceedings in local courts are held in Arabic, although interpreters are available. Local law is Sharia-based, and so this is the law understood by the judges. Where you come from a common law jurisdiction like the UK, your will is prepared under a legal structure which is not familiar to the UAE judges. Consequently, there is a significant amount of uncertainty over how the local courts will interpret your will. Not only are the outcomes unpredictable, they are also lengthy and therefore expensive. When asked, a local lawyer quoted a figure of between 50 and 100,000 dirhams in legal fees alone. The situation is harder for Muslims who do not want their assets distributed according to local law, although not impossible, depending on factors such as the type of assets in question, family structure, and how you want those assets to be distributed. From the 1st of February 2023, UAE Federal Law 41 of 2022 on personal status came into force. This legislation has important implications for British expatriates in the UAE who do not have a will. The law distinguishes between Muslims and non-Muslims, making it clear that non-Muslims are not to be subject to Sharia-based distribution of their assets in the UAE. Whereas previously, distribution of assets in the UAE were heavily in favour of the male side of the family, this is no longer the case for non-Muslims. Now, gender has no effect on the level of distribution of assets in the UAE for non-Muslims. For example, under Article 11 of the law, where there is no recognised will in place and the deceased was married with children, half of their assets will go to the surviving spouse, whether male or female, and the other half is divided equally between the children of the deceased. This is a significant divergence from the Sharia distribution of the past, where the wife and daughters of the deceased lost out to the male heirs. Whilst a welcome step in the right direction, most expatriates I speak to want their spouse to receive all of their assets on their death, and for the kids to inherit on the death of the last of their parents. This is to ensure that the surviving spouse has enough to meet their needs without relying on handouts from their own children. Although the law is now in force, it is a federal law. Each emirate has the right to interpret the law as their court system sees fit. We will have to wait and see how they go about this. Whilst a will is an important legal document for distributing assets on death, there are other ways of managing the transfer of assets. In the UAE, joint bank accounts are frozen on the death of one of the account holders. This is not the case in the UK, Channel Islands or the Isle of Man. In these jurisdictions, the survivor automatically owns all of the balance with no need for probate. Therefore, I recommend keeping emergency money in a joint bank account offshore. Whilst it's common for joint account holders to be married, this is not mandatory, and therefore unmarried couples or parents and children can benefit from this strategy too. However, there may be UK inheritance tax implications where one spouse is not UK domiciled or the parties to the account are not married, such as parent and child accounts. Trusts are a very well tested method for managing the transfer of assets to another person whilst retaining some control over how they're used. As trusts are legal entities in their own right, they can be established during your lifetime and your wishes control them after your death. Life insurance should normally be held in trust for the benefit of the surviving spouse or young family. This results in the beneficiary getting access to the proceeds faster than having to wait for probate to be completed, which may take months or over a year. UK pensions are usually structured within a special form of trust. Members of the pension scheme nominate a beneficiary of the pension fund in the event of their death. This results in the right money getting to the right people at the right time. Although it's important to keep your death benefit nomination form up to date with the pension trustees. Real estate in the UK is most often owned in the same way as joint bank accounts, i.e. both owners own all of the property. So if one of the parties die, the survivor automatically inherits the whole of the property. However, as with jointly held bank accounts in the UAE, jointly held real estate is also potentially a problem. The most legally robust method of transferring assets in Dubai for non-Muslims is to use the Dubai International Financial Centre DIFC will. These wills cover guardianship of young children, property, financial assets and business assets. The DIFC will service provides a tried and tested route for non-Muslim expats. It enables non-Muslims to distribute all of their assets within the UAE and make guardianship arrangements for their children. Whilst they have received criticism for their registration fees, which are up to 15,000 dirhams, about $4,000, the cost is relatively small to the potential legal fees associated with using a home country will via the local courts. The administration of estates via the DIFC is also faster than via the local courts, which reduces the time your family need to spend in the UAE winding up your estate. Further, if the real estate in Dubai is distributed according to local law and the Sharia beneficiaries agree to transfer their rights to the surviving spouse, there may be a number of consequences. Firstly, the Dubai Land Department may charge registration fees of the property into the Sharia beneficiaries' names and then to the spouse. And for UK domiciled spouses, the transfer to Sharia beneficiaries is not exempt from UK tax. This means that there may be higher death duties to pay in the UK. Therefore, whilst the will registration fees may appear high, it may be better to think of the will as an insurance policy protecting your family against the consequences of living in the UAE if you die. Great British Wills does not provide DIFC wills, as we specialise in providing wills under English law, but we can introduce you to lawyers registered with the DIFC who can help you. Living in a foreign country is exciting and brings many positive experiences. However, it also holds risks that we're not exposed to in our home countries. One of these is the fact that the legal system is very different to the UK, especially concerning the treatment of our family and assets in the event of our death. I hope that this video has helped answer some of your questions about wills and guardianship in the UAE. Please contact me via the website greatbritishwills.com if you have any questions, and don't forget to like and subscribe.